What is that? All right. Sorry I'm late, folks. Let's share this real quick. Check it out. All right. Am I buffering? Safety man, am I still buffering? Wi-Fi versus the phone internet. What's up there, Cindy? Winch with the wrench. All right, so we're gonna get started here. Let me get into this here. So let's see. I got a good bit of stuff prepared. I'm running a little bit behind, so I'm trying to figure out where I'm getting started. Thunder Rolls Media, hello. Welcome everyone. Lurking trolls that are not quite talking shit yet. All right, so here we're gonna touch on a random thing today. So locally, with my local LaPorte Police Department. What's up there, Huckleberry? I'm quite often deemed as threatening the police with violence when I mention that I will defend myself in accordance with Indiana law. Indiana's self-defense laws allow an individual to defend themselves against public servants, specifically warrantless searches. You know, basically the police kick in your door and they don't have a warrant in the state of Indiana. There is no, there's no question about what the legalities are. The citizen in their home has the right to defend themselves, utilizing up to and including, I believe the word is either deadly force or fatal force. I can't remember right now. But it's basically, the officer can die if their actions are illegal. So be it. Now, mind you, their actions are usually legal. But anyway, I'm locally, known with the police here, as quoting, that I know I have this right in Indiana as a citizen here. If you watch my videos, it's one of the reasons why the police haven't actually killed me yet. So one of the things locally that I've got going on is, what's up there, Chi-Town citizen? We're about to have our local municipal elections. One of the guys that's going to be running for mayor, his name is Tom Dermody. I actually just said it wrong because I misspelled it here and I read it wrong. They added it in. Anyway, Tom Dermody. Another individual we have running for mayor is Tim Stabos. I love her.
Hey.
Anyway, so Tom Dermody just so happens to be on this amicus curiae brief for the Indiana Supreme Court. This would be a Richard L. Barnes versus the state of Indiana, and the docket number is 82S005-1007-CR-343. What's up there, Civilian X? Now, basically, this is a brief on behalf of several individuals, organizations, shit like that. Amicus curiae is basically a friend of blah, blah, blah. Anyway, we're going to do that in the whole thing. I want to do a whole nother little episode on this, the amicus thing. Anyway, the dude that's running for mayor is one of a long list of names that these are all senators and representatives for the state supporting this change that happened to Indiana's self-defense law. So basically, he's one of the guys that made Indiana's self-defense law include public servants. So from what I hear, rumor has it, the police in my town might not support this mayoral candidate, which is going to play out very interestingly. Because, the mayor is sort of the boss of the police. It'd be interesting to see them not like him. Anyway. Man, I'm just not with it tonight. But I made a commitment to you guys Fridays at 9, so here I am. One of the reasons, actually, I chose the topic of search and seizure tonight is, in my situation, one of the big things, if you watch my videos, is that at one point, the LaPorte Police Department was having me patted down, or actually the LaPorte Police Department was enforcing this order, which we're going to get to that, from the city attorney, which is basically, I refer to these as love letters because they're definitely not court orders. Matter of fact, these are what court orders are like. See, a court order has a judge's signature on it. There's another one for you. That's a lot of people. It's a lot of judges. It's a lot of individuals showing up to court. You know why? Because the judge has authority. These are signed by an attorney. These are short of my personal interest, nothing but recyclable. They have no authority. So at one point, I file a complaint. Let me give you a little bit of context behind this. Long story short kind of thing. I file a complaint against the LaPorte Police Department August of 2015. When I go to pick up a copy of my complaint, I was sort of taken a little bit off guard, because when I showed up, it was the chief of police. So it just kind of caught me off guard a little bit. And lessons learned, I didn't read what I was signing. I thought I was just signing a basic acknowledgement of receipt. Here we gave him a copy of this. Attorney has left the city. That city attorney, yes, she's in Indianapolis now. They basically invented a job for the old mayor. She followed shortly after her. We'll get to that. Anyway, so I go to pick up my copy of my complaint, and it's the chief of police. I don't read what I'm signing. What it happens to be is, yes, we gave him a copy of this. You can't talk about it. Notice of confidentiality. So I basically signed a notice of confidentiality because I wasn't paying attention. Lesson learned, pay attention. Always read something before you sign it, the entirety of it. Basically, nothing happens as you would expect. They had me sign a confidentiality agreement based upon my complaint. Basically, this chief of police, who's no longer the chief of police, mind you, he was, he resigned to captain, and I'm trying to figure out if he still works there, because the 2018 city finances, his number seems a little low, like maybe he only worked 3-4 months out of the year kind of thing. I just put in a public records request for that, by the way. Anyway, I heard some very interesting information that would have him being prosecuted and maybe registering as some sort of an offender. Accusations that sort of thing was going to play out the day before he resigned officially. So digging into this. Anyway, the chief of police at the time refers me to the LaPorte County Prosecutor's Office, who was then ran by John Esbar. He is no longer the prosecutor either. Anyway, the chief of police refers me to the prosecutor's office. I go to the prosecutor's office and basically explain to them, I have no idea why the fuck I'm here. But they told me to come here to seek further documentation on my civil complaint. I don't know why they would refer me to the prosecutor's office, because it's not a criminal matter, but they do. So here I am. Basically the woman who no longer works in that office. What's up there, James? She basically hits some sort of a panic button on me, because I tell her that I would like to speak to the actual prosecutor, and when she tells me that he's not available right now, I say that I'm going to wait in the chair that's in what I presume to be a waiting area, because there's chairs and magazines and things of this nature. So I sit down and I start reading about, their little pamphlets and stuff, the Victims Advocate Division, things of this nature. Next thing you know, about 5 police officers from the LaPorte Police Department, including the chief of police that just told me to come down there, shows up and is basically like, are you refusing to leave? Are you refusing to leave? Are you refusing to leave? And like they're trying to conjure some sort of spirit out of my body, they just chant in unison, "Are you refusing to leave?" Until I'm basically like, okay, this is getting a little weird. Like you guys are about to do something strange, possibly aggressive. So I leave. I try this again about a month later. The exact same thing happens. I try to wait. They hit a panic button. By the way, panic button basically kills a good bit of the documentation as far as communication between two different agencies goes. It's a direct thing, and they just come, and there's no report of why they're showing up, things of this nature. So they don't have an actual reason to be there, which means they're able to make up a reason as they go. It's pretty fucking convenient. The panic button thing's very sketchy. Anyway, so we do this panic button thing twice. It pretty much goes the exact same way both times, except for the second time it's about 2 more cops, for a total of maybe 7. And now we have some as well as we have some sheriff's office people tucked in there at one point. So this doesn't go well either time. I don't get any information about my complaint. I don't find out anything. I'm told to be investigated. Here's your copy with sign this confidentiality waiver, yada yada yada. And they send me on my way, and then they show up and they basically, coerce me. This is what this is called. This is called coercing someone into leaving. They basically create an environment that you're uncomfortable in, so you leave. Now, I wasn't actually trespassing. That's the thing. But what they do is they show up and they say, "Are you refusing to leave?" like 30 times until I presume it's going to go negatively and I leave. So I take about a 4-month hiatus and I read up on several things. And February 5th of 2016, I file some public records request. I just so happen to be recording. Now, February 9th, 4 days later, because on February 5th, City Hall, the mayor's office, they took my public records request, no problem. I went down to the police department and attempted to give them public records requests. They refused to take them because records was closed. This was February 5th, 2016. That sign is still up. I would almost guarantee it. It's been up every time I've been there since then. Anyway, so they refused to take my public records request on February 5th, 2016, which was a Friday. I go back Tuesday, February 9th, attempt it again. One of the individuals who was named in my original complaint is there. She basically is assistant chief number 2, badge number 2, Julie Smith, tells me basically that they don't deal with public records requests. Now, if you watch my videos, you've seen I've taken numerous public records requests to the Port Police Department since then. But at the time, she tells me they don't deal with that, which I know to be, false. So I go down to City Hall and I attempt to make another complaint because now we have what is called a Human Rights Commission. So I'm down there trying to find this Human Rights Commission or some sort of information on it or locate the individual that I previously made my complaint to, the city attorney. The police follow me down here. And basically that's where, my videos begin. They follow me around there and basically, "Are you refusing to leave?" And in between, it's a couple blocks in between these two buildings. I think I walked too fast for them or whatever. I don't know. Anyway, they don't lock the building down. They just all hide in their offices and close their doors and such, and they pretend like they're not there. Meanwhile, I walk around the building, sort of confused as to what's going on, while these cops are trying to bait me into arguments, and I'm responding, and then I'm baiting them into arguments, and they're responding, and we're having a little fun tit for tat, and then this assistant chief of police shows up and says I'm officially being banned from the building. I'm on a trespass list, blah, 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 blah. So I'm like, okay, this sounds kind of questionable, but I'm not going to risk going to jail, so I leave the building. I get out on the sidewalk, and one of these officers, Michael Sliwa, who's no longer with the department, basically says that I'm still on city property while I'm on the sidewalk. So I basically am like, it's all city property. So I get in the road. We have another little exchange, and then they say bye, and I say bye, and I walk off, and no sooner than I turn around and walk off, the Officer Reed, by the way, who's one of the three officers who let this drunk EMT go, and he killed 2 people. We refer to him a lot in my video. He's, I know you smoke. I can smell the cigarettes on you. I know you're going to go outside and it's going to be funny, and ha 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 ha. It's fucking not so funny anymore, is it, Officer Reed? Because he testified under oath that he couldn't smell any alcohol on this guy that he let go, because this guy was his buddy. And then his buddy fucking killed 2 people. Anyway, so Officer Reed then tells me that I'm obstructing traffic because I'm walking in the road. And then I end up with a disorderly conduct for telling them that they're basically fucking stupid hillbillies, because how do I get home now? Because the sidewalk and the road and everything's a crime now that I'm walking on it. Everything's off limits, so how the fuck do I get home? So I end up with disorderly conduct, and they tackle me and all this shit. So I end up with resisting and battery on a police officer. And anyway, all these charges get dismissed. But the point of this is February 9th, 2016, they generate this no trespass order. Julie Smith claims, the city attorney, blah, 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 gave her the agency necessary to trespass me from the building. It's actually dated February 9th, 2015, and not 2016. On accident, I presume. Anyway, please be on notice that due to your previous interactions at City Hall, I presume that was 4 days before, not 6 months before that. Please be on notice that due to your previous interactions at City Hall and the fact that several staff have experienced concerning encounters with you when you visit recording, you are no longer welcome at City Hall unless it is for an officially scheduled public meeting. You are hereby notified that you are on the trespass list. If you violate such notice, you will risk being arrested. Now, interestingly enough, I was read this after I was already arrested for trespassing while I was in the back of a cop car. That's not how notification works. If you were actually putting me on a trespass list, I would have to leave and then come back, and then maybe I would be trespassing, but it's still public property, so there's a whole bunch of arguments behind that as well. Anyway, that's the gist of it. Not the gist of it. That's the entire thing. Is due to concerning encounters, you are only allowed on the property for public meetings. Okay, so about a year later, and 549 days after my original complaint, or before my original complaint even, this was prior to me giving my complaint, this incident happens. But this is 549 days later. February 21st, 2017. Just so happens to be the day that I'm there to citizens arrest the mayor and the city attorney. Dear Mr. Throgmorton, please be on notice that due to your previous interactions at City Hall, 801 Michigan Avenue, LaPorte, Indiana, and the fact that several staff have experienced concerning encounters with you, including, but not limited to, displaying knives, threatening to make illegal citizens arrests on employees when you visit while not stating actions committed. I go into a good bit of fucking detail. Yelling at several staff members. It's one of the best ones. Coming unannounced when asked to make appointments to address any of your concerns. You are no longer welcome at City Hall unless it is for an officially scheduled public meeting. Coming unannounced when asked to make appointments to address any of your concerns. Okay. For yelling at staff members, displaying knives, threatening to make illegal citizens arrest. If, by the way, an illegal citizens arrest is a crime, which I have not been prosecuted for. And coming unannounced when asked to make appointments to address any of my concerns, even though I'm only allowed there for an officially scheduled public meeting. You are subject to a pat-down when you enter the building. The city will continue to provide you access to all services afforded to any citizen. You are on notice to please provide your request in written communication, schedule an appointment, or come to a public meeting where you have legitimate business to conduct. Very truly yours, Rebecca McQuaig, City Attorney. So, you are subject to a pat-down when you enter the building. This is a search and seizure. I have been stopped. This is specific to me, and I'm being searched, okay? Now, the reason for this is, you know, they're going with the a threat and blah 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 blah. We consider you to be dangerous. Now, let's address the first one. Well, hold on. We'll start from the bottom. Coming unannounced when asked to make appointments to address any of your concerns. Well, that's fucking ridiculous because I'm only allowed there for an officially scheduled public meeting, and if I would have came unannounced, I would have been arrested. Yelling at several staff members. Again, what is a pat? If I get patted down, am I going to come in there and not be able to yell? Doesn't solve that stupid reason. Threatening to make illegal citizens arrest on employees when you visit while not stating actions committed. Here in Indiana, we have a process for a citizen's arrest. It's very much so legal. If you illegally arrest someone, it means you've actually went through with the process, and if it's found that you don't have a good enough, you don't have probable cause, the same way you're held to the same standards as the police and such, even higher standards, to be honest, for a citizen's arrest. Anyway, if it was an illegal citizen's arrest, I'd have been arrested. They chose to employ their police to prevent me from making a legal citizen's arrest. And I maintain that if it was an illegal citizen's arrest, let me go ahead and do it. So you can prosecute me, whatever officers are watching this or, whatever. Anyway, so last but not least, displaying knives. Now I say 549 days after because this is 549 days after I literally displayed a couple of pocket knives, okay? Now, when I say displayed, I don't mean I pulled pocket knives out and I was like, huh, let's sword fight. I mean, part of my complaint is me mentioning that 2 police officers confiscated these knives without, any legal justification. And then upon returning them to me, 2 different officers threw them at me, which is basically disrespectful and borderline unsafe. The city attorney who took my complaint after I told her this, and is later describes herself as sort of being my friend, and she's able to, to talk me into a chipper mood when the city's lying to me. She basically asked me about these knives. I pull them out of, off my clips, off my pockets, and I have them in my hands, which both of these knives are about the size of a big lighter. One's a little bit smaller. And I show them to her like this, closed, little bitty pocket knives, open palms like this, and then I put them back in my pockets. And then I go on and have another 10, 15-minute conversation with her, and then she later meets with me. Let's get into the technicalities of this. The wording is very unique, but it's very specific at the same time. Displaying knives. That's exactly what I did. Notice how she didn't say, though, brandishing a weapon. Then, knives in the state of Indiana specifically are defined as intended to be used as a weapon. Now, if I'm not intending on using this as a weapon, technically it's not a knife. It's what I say it is, a tool. Which, by the way, for all you trolls out there talking about the whole, you don't have a job, get a job. If you watch my videos long enough, you'll figure out that the reason I have these knives and where I lose them, things of this nature. Anyway, I usually keep a flat blade and a serrated edge blade because I cut a lot of rope. And I live in a town with a bunch of lakes, and I pretty much have this badass schedule, and you can't track it down for a very good fucking reason. Anyway, figure it the fuck out. The point is, one of these knives is in the bottom of Pine Lake. If you find it, I'll give you like $20. Anyway, the other one I still have. Nope, not a tree climber. Good guess, though. I knew somebody would come up with that. Close. Notice I didn't mention any trees. I mentioned lakes. Anyway. Other hand. I have a lot more free time when it's cold and there's snow. So this pat down thing, this is definitely a search and seizure, and this is where a lot of the public records that end up denied, that I go through the court process with, and I get a real court order for these documents. One of those documents, or several of them actually, outlined in that court order, describe some of these days where there's these pat downs, as well as the day where I refuse the pat downs, and I'm locked outside of a public meeting for about 2 hours, while they waste a bunch of time and money. They got about 4 or 5 officers out there, while they try to find something other than this letter, because the city attorney lied to them, and she called it an order, but in reality it was just a letter she wrote that she didn't give to me in the proper way, so it's garbage, and they both are pretty much recyclable, and that's about it. Anyway, What's up there, James? Thank you very much. Yep, every Friday we're here. So, one of the reasons why I wanted to address this was to clear up all this nonsense, because I see, a game of Chinese telephone. Excuse the racism there, but I don't know any other way to describe it. But basically, where there's a lot of misinformation and disinformation in the comments and, the trolls. I've seen where I'm accused of bringing a dozen knives into a public meeting. And it's not the case, folks. These individuals focused on the wording of not illegal actions, which, by the way, if what we're talking about is a knife, and we're going to describe it as a weapon, that'd be covered under the Second Amendment, which is a whole another ballpark. But I mean, I have a federal gun case. I was really like the last fucking person on the planet that the LaPorte Police Department should have tried this dumbass nonsense with, because of my criminal history. I clearly had to know a thing or two about, some of this stuff based upon my cases. Anyway, so we are going to get into this search and seizure stuff. And I've got, I got some little bit more known stuff, common knowledge, but I've got some Indiana specific stuff, and then just some interesting things I found about definitions and things of this nature. What's up there, Maui? Happy Friday. I'm all right. How are you? Thank you, by the way. All right. So starting off, this is pretty much your more known shit here. Terry v. Ohio. This is basically your Bible as far as pat down searches go. Long story short, in a traffic stop for officer safety, things, for an officer safety, they can pat you down for a weapon. This is called a Terry stop. Terry stop does not give them the rights to search various other things, and that's kind of what we're going to get into. Is when they can't search, not so much when they can. When they can search is important. I have a little bit of that that we're going to discuss tonight, but mostly I'm going to try to get into when they cannot search. However, drink a lot of coffee, so you guys have to give me one moment here. I'm going to go use the restroom. I will be right back. Gotta love the trolls. You guys literally have like an issue with everything right here. IH Zook. You couldn't use the restroom before you started? Rude. We've been going for about 45 minutes here, and everything you say on my videos is rude, and I don't even give a shit that you're here. Like, they can even block you for all I give a fuck. Anyway. Actually, yeah. So, really quick, I'll touch on this real quick too. This would be the second petition for appointment of a special prosecuting attorney. Now, this is the newly elected prosecutor. So, it's all three: trespass / resisting, the battery from when the guy tried to grab my phone, and the intimidation on the city attorney and from the court order, schmoed order video. So, there's that, which means, I'll probably still have court February 14th, but it's not going to be my final pretrial conference as it was supposed to be, because the new prosecutor himself, even if he wasn't recusing, would need a little bit more time to probably prepare. It's up there, Regina. But a special prosecuting attorney is definitely going to need a little bit more time to get familiar with 3 cases. Need some sugar. No. December 20th, I was supposed to have a hearing on my motion for special prosecutor, special judge, special public defender. It just so happened I brought a court-ordered psych evaluation from my 2016 arrest that states that I have Asperger's. And essentially, because I was forced to prove that I have autism to the judge, which, according to the judge, I proved I have autism. I was granted this forensic advocate. Now, because he granted me this forensic advocate, he rescheduled all of my other stuff that was supposed to transpire that day, such as motion for special judge. So this judge would have been essentially forced to recuse. He should have recused from the beginning because he formally prosecuted me. And when he formally prosecuted me, he tried to unlawfully file a habitual offender enhancement against me, as well as a few other different forms of misconduct. In my case, however, there's 5 judges in this county. 4 of them had already recused. He was the 5th one. He chose not to recuse, and now if he recuses and I get a special judge, which, like I said, he should have recused already, but after this hearing was canceled, there's some things that transpire in some emails between him and Indiana Disability Rights Advocacy Group, the information and referral coordinator, Mr. Dan Ward. In these emails, the judge mentions a phone call that he had with Mr. Ward, and he basically says that, he states his medical opinion, which he's a judge, he's not a licensed psychologist, checked. So these ex parte communications, which in and of themselves are not done lawfully, because I'm supposed to receive notice prior to them transpiring, as well as have an opportunity to object, or respond otherwise. But aside from the fact that these ex parte communications were done inappropriately, he mentions this unlicensed medical opinion, which is a form of bias. You did hear a bird. I have several of these. They're from the Audubon Society. Each one makes a different bird chirp sound. I've got like 3 or 4 of them, I think. All of them are from Goodwill. And $1.50, maybe $2 is the most I've paid for one so far. But a couple of them are different, but 2 or 3 of them are the same. Anyway, lost my train of thought. Oh, okay. So this judge is going to recuse. I'm currently in the process of writing up a complaint about all this. This is, it's inappropriate in multiple aspects. It creates a whole new, criterion for recusal that I'm meeting, as well as, irreversible error. I have no idea what transpired during this phone call between this judge and this individual, but I know the judge basically diagnoses me with a oppositional defiant disorder, which is essentially a basic disobedient child. And then the disability rights advocacy group says something along the lines of, to pacify him, just tell him that his public defender can call us. So, disobedient child, pacify the disobedient child. This shouldn't be transpiring in an email between a judge and a disability advocacy rights group prior to these individuals. This group never spoke to me. This all happened basically because the individual that does it has a criminal justice degree, and that's why the conversation with me sounds like a cop interrogating me, because it's probably not appropriate for his job. Not to get too far sidetracked from all that, but anyway, that's sort of just an update with everything I got going on. Yes, so every hour the birds chirp. Yes. It's different. It's different than the bells and stuff. After a while, you you sort of hear the time based upon the bird. You know what I mean? Like you start to associate like, you know, 2 o'clock as a black-capped chickadee. You hear a certain bird and then you're like, oh, it's 2 o'clock. It's yes, it's very calming. My world is sensory based first and foremost. So you know, I'm all for anything that's calming. Anyway. Okay, Cindy. So what Cindy's asking about is I have a German short-haired pointer named Peppy or Peppergus. But she's a hunting dog. She's a gun dog. Her breed specifically is made to hunt a lot of stuff. Bear, deer, boar, all kinds of things. Come out in the backyard and she's in the tree because that's what she does. Her breed is pretty interesting. Anyway, so she's a bird dog among other kinds of hunting. And at first she was pretty tripped out with it. When we got her, she was around a year old. And you know, there's pretty much one in every room. So it's, she took a while to get used to them. But she does this like standing hop thing, like not like a run and jump, but like just pop, we call it popcorning. Like she jumps from like a standstill straight up in the air, about 6 feet high. Like she'll stand in front of the front door and jump up and down and look out the window in the top of the front door. But she would jump up about eye level with these clocks for quite a bit. So in the beginning, when we first got her, when the clock would go off, you would hear it like thump, thump, thump. Her jumping up and down and looking at these things. Carissa's got some good pictures of her like looking up at the clocks as they are going off. Anyway, yeah. Troll actually made a point. Can we get back to the topic? All right. So all right, so for my Indiana people, Indiana Code 9-19-10-3.1. A vehicle, the contents of a vehicle, the driver of a vehicle, or a passenger in a vehicle may not be inspected, searched, or detained solely because of the seatbelt law. This was upheld in State v. Morris, 732 NE 2D 224, Indiana Court of Appeals, 2000. The plain language of the Seatbelt Enforcement Act evidences legislative intent that traffic stop based upon seatbelt violation, standing alone, does not provide reasonable suspicion for police to unilaterally expand their investigation and fish for other crimes. Again, in Clark v. State, 804 NE2D 196, Indiana Court of Appeals, 2004. Officers are strictly prohibited from investigating anything else after a stop to determine seatbelt compliance is completed. Absent reasonable suspicion of criminal activity officers could not even ask defendant for consent to search vehicle. Again, Pearson v. State, Pearson v. State, 870 NE2D 1061, Indiana Court of Appeals, 2008. During a lawful pat-down search after a seatbelt stop, officer was not justified in asking defendant if he had anything on his person, which led to discovery of marijuana and meth. Interestingly enough, this dude had a lot of meth. But because it was a seatbelt stop and they don't have any lawful reason to search you, this dude basically handed the cop a bunch of meth, and he beat it on appeal because they're not justified in asking the defendant to even consent to the search. All right, so a lot of people are familiar. You should be if you're out doing audits and you don't want to ID. Hibble v. 6th Judicial District Court of Nevada. It's 542 U.S. 177, 124 Supreme Court 2451, 159 LED 2D 292. It's from 2004. A person cannot be stopped and asked to identify himself without the stop being based on objective facts establishing reasonable suspicion to believe that the suspect was involved in criminal activity. Here in Indiana, we have Holly v. State. 918 NE2D 323. It's an Indiana 2009 case. The registration was to a woman who had a suspended license. They stopped the car. Once the officer realized that the driver was a man, the officer's request for identification was unconstitutional. Here in Indiana, we also have Greeno v. State. That's 861 NE2D 1232, Indiana Court of Appeals, 2007. This is basically the case that outlines that a passenger in a vehicle that is pulled over for a traffic stop does not have to identify. Again, the passenger in a vehicle for a traffic stop does not have to identify. That is Greeno v. State. What bird is Sig's house are in? All right, so in Indiana, ordering a defendant to stop and come back required the officer to have reasonable suspicion, which he did not. That is also Greeno v. State. The reason for this is stop, come here is a Terry stop, according to Dowdell v. State, DOWDELL 747 NE2D 564, Indiana Court of Appeals, 2001. Reasonable suspicion for a Terry stop does not give, reasonable suspicion that gives authority to a Terry stop does not, without more, authorize the examination of the contents of items carried by the suspicious person. Berry v. State, Berry v. State, 704 NE2D 462, Indiana, 1998. The search of a car, the consent to search the vehicle, does not automatically imply consent to search a backpack in the back seat. Norris v. State, 732 NE2D 186, Indiana Court of Appeals, 2000. The search of a car with a male driver does not give probable cause to an officer to search a purse. State v. Friedel, Friedel, 714 NE2D 1231, Indiana Court of Appeals, 1999. All right. All right, so I'm a hard no on letting the police in your home for any reason at all. If they want to come in your home, they can go get a warrant. Without a warrant, you shouldn't let the police in your home. The reason for this is because there is really no sorts of checks and balance if you give them consent inside of your home. They're pretty much allowed to do whatever the fuck they want based upon technicalities. So, Buckley v. State, 797 NE2D 845. This is Indiana Court of Appeals 2003, which states the defendant's consent. Actually, hold on. I need to do. Actually, all right, different case. Hold on one second. As long, this would be Litchfield v. State, 824 NE 356 363, Indiana, 2005. Pretty much the exact same wording and upheld in Hoop v. State, 909 NE2D 463, Indiana Court of Appeals, 2009, which states that as long as the officer is lawfully on the premises, the officer may have a dog sniff the residence without implicating the Fourth Amendment. Now, in Indiana, a search is defined as implying prying into hidden places for that which is concealed. Peterson v. State, 674 NE2D 528, Indiana, 1996. Buckley v. State, 797 NE2D 845, Indiana Court of Appeals, 2003. Defendant's consent to search his home for officer's safety did not allow officers to search any container in his house. Okay. Jones v. State, Indiana Court of Appeals, 409 NE2D 1254. A search without probable cause is never justified by need to prevent disappearance or destruction of evidence of crime. All right. Now, if you're in your house and the police are there, here in Indiana, specifically, if you watch my videos, there's the February 9th video with Officer Reed when they're basically trying to coerce me into leaving City Hall and they're pretending nobody's there. He basically says nobody's answered the door, so I should leave. When they knock on the door and nobody answers, they have to leave. And I tell him, that's fine. You're held to a different standard than I am. Now, the standard that he's actually held to is Cox v. State, 696 NE 2D 853, Indiana, 1998. After receiving no response, officers should have left, as purpose for their visit to that property terminated due to lack of response from any occupant. Otherwise, the well-established right of citizens to refuse to answer their door would be illusory, because a reasonable person would not feel free to leave home when police continually knock on windows and shine flashlights into home, and thus would be seized. United States v. Jerez, Jerez, United States v. Jerez, 108 F 3D 684, 7th Circuit, 1997. Now, your home is surrounded by an area called curtilage, okay? A good case to figure out about curtilage is US v. Jenkins, 124 F 3D 768. This is 6th Circuit, 1997. A rural backyard, partially surrounded by a wire fence and set well back from public road, constituted curtilage of residence and was entitled to Fourth Amendment protection. Factors considered in determining whether an area is curtilage are the proximity to the home, whether the area is included within an enclosure surrounding the home, the use to which the area is put, and the steps taken to protect the area from observation by passerbys, all weigh in favor of finding of curtilage. Okay? Now, the reason, hold on. Here's a good one. Suspect did not abandon briefcase by tossing it into his own backyard as police arrived to serve warrant for his arrest. Fenced yard was part of home's curtilage, and suspect retained expectation of privacy. Officer who observed could legally seize pursuant to a valid arrest and get a warrant, which would be required to open this briefcase. However, the wording is very specific. The warrant would be required, it would have to be pursuant to a valid arrest, and the officer would have to observe the item being tossed onto the curtilage. I'm doing a lot of Indiana laws. I have some federal stuff tucked in here, but it's what we're focusing on a lot is terminology. I try to encourage people to self-educate more than just give you the information. So I do this a certain way to provoke you to do that, because as always, this is just no material. We're just chopping it up. We're just having a conversation here. But the purpose is for you to get intrigued, curious, engaged, and to do your own research, because you shouldn't just trust what I say. You should know it. Anyway, so federal. Grow. Actually, hold on. All right. As far as warrants go, search warrants. Grow v. Ramirez. GROH v. Ramirez. 540 U.S. 551. This is a 2004 case. A search warrant which does not describe the things to be seized is defective, even if the application for the warrant does describe the things to be seized. The reasoning for this is no reasonable trained police officer could have believed that a search warrant completely lacking a description of items to be seized could be valid. Hester v. State, 551 NE 2D 1187, Indiana Court of Appeals, 1990. Also in Hester v. State, a warrant that leaves executing officers with discretion is invalid. An anticipatory warrant, which is a warrant which relies on a future act to establish probable cause. In Indiana, according to Indiana Code 35-33-5-2, lowercase a in parentheses, 2 in parentheses, capital A in parentheses, is deficient on its face. This was upheld in numerous cases. Newby v. State, NEWBY v. State, 701 NE2D 593, Indiana Court of Appeals, 1998. What else? United States v. Socolow. I think that's how I say it. SOKOLOW 104 LED 2D 1046. The Supreme Court has held that a law enforcement officer made a permissible stop of an accused in conformity with the federal Constitution's Fourth Amendment, where the officer approached a parked vehicle in which the accused was sitting and requested that the accused alight from the vehicle. But the court has recognized that an officer's use of excessive force in making an investigatory stop violates the Fourth Amendment. another good case to read up on. This is mostly pertaining to automobiles, but there's some language applicable in here to some other stuff. This is Patrick Knowles v. Iowa. KNOWLES 525 US 113. Argued November 3rd, 1998. Full search of automobile as authorized by Iowa law by police officer who issued speeding citation rather than making arrest as authorized by Iowa law, held to violate federal Constitution's Fourth Amendment. Let's see what you guys are talking about and how. Fanny packs, huh? If Chris was a bird, what kind of bird would he be? Do I get to choose? Because I would probably go with a dark-eyed junco. They're like charcoal gray up top and then white on the bottom. They're the winter visitor. Anyway, so let's do some Q&A. What's going on in the chat? I'll be there on the 14th. As of now. Maybe canceled by then, but probably not. It'll be rescheduled. Oh, by the way, I know somebody in the comments said, they don't like my shirt. Something a 15-year-old would wear. But not only is my general conclusion based on my own observations that I must be illegal. That's why the police are following me around and shit. But there's more to, it's like I'm voicing my solidarity with asylum seekers, immigrants, all of those people. I don't believe in any of that searching through the desert to find water so that we can pour it out because fuck those kids, build the wall, all that bullshit. You want to start getting rid of people, rich, old, white people with suits and ties on in Washington, D.C. That'd be a good place to start if you want to get rid of welfare recipients and everything. Like specifically, I live in LaPorte, Indiana, which was established in July of 1832, which is almost 2 years after the Indian Removal Act, which was signed on May 28th of 1830. So, like, locally, I don't give a fuck about anybody's views on immigration because this place, La Porte, the door, was essentially established by European immigrants who purchased the land from the government after they took it from the Native Americans in a big, bloody, brutal, bullshit fucking way. And I wear this shirt because I don't agree with any of that. And I essentially, I'm illegal. I acknowledge that I'm an illegal immigrant. I'm an anchor baby because my last name's Throgmorton, which goes all the way to Europe. Pretty easy to track back as well. So pretty concrete evidence that I'm the product of European immigrants, as well as, you know, I got a bunch of Cherokee and some other stuff. Anyway, so if you don't like my t-shirt, I don't really care. It's the darkest part of my lily white ass. If you do like my t-shirt, I believe you can go to the 5th column on Facebook and contact them, and they should hook you right up. It's like t-shirt, I don't know whatever the fucking website is they use. Anyway, I got it through the 5th column, but I've seen comments. You know, some people hate it, some people like the shirt, some people comment that they love the shirt. So if you want to get yourself an I'm illegal t-shirt, go to the 5th column. It's a good place to get your news as well. Antigua. A tiny island. Where do you live now, James? Very good point, Joe Black. Very good point. You'd think a court-appointed advocate would be a little bit more of the court's job than it is my responsibility to, like, I mean, I go to a lot of people about this. I did a lot of research. You know, the judge had one phone call and typed up a couple of emails. That's about it. But I don't know. I'd like to go pro se, and they don't want this, and I don't want to really deal with their hybrid counsel bullshit. So I was sort of trying to meet them in the middle with, you know, there seems to be some sort of communicational barrier to where I'm not allowed to, you know, do this according to the judge. So I offered this forensic advocate idea as a sort of concession with the judge and the court. You know, you guys need me to have a middleman. Like the court needs me to have a middleman to be able to represent myself with their hybrid counsel thing. So as opposed to this hybrid counsel thing, what about a court-appointed forensic advocate? I think that they appointed me this forensic advocate on a whim, probably to reschedule this hearing that would have got this judge off my case and stall until after the new prosecutor took office and things of this nature. I don't think they counted on this new recusal happening. But nobody looked into it. I requested this thing for a couple months, and when they appoint me, they have no idea that the judge's email, he says, if the statute exists, which he issued an order where he quotes the statute. So they're even going back and forth about if they even believe that it's a real Indiana code, to quoting the Indiana code, to talking about it like it's not real. But the reality is, I think I'm the only person in the state who's been appointed one of these forensic advocates. And I think, from what I understand, I'm the only person who's interested in being a forensic advocate. As far as I can tell, there's no program for this. As far as training, there's minimal statutes about the stuff. There's a little bit of funding and a couple different statutes, but it also says that I'd be responsible for paying. But as far as all these people, the experts, nobody knows anything about it. Like, in one of my videos, I call Indiana, with a Indiana code, with a statute, created an autism resource center that's located at IU Bloomington, which is a great school. They have a great law school there as well. Now, I would have thought that this autism resource center would have at least heard of it, you know what I mean? But there's a IU Moore School of Laws there as well. It's great law school. It's one of the top 10 law schools in the country. I would have thought that with that combo, located right there in IU Bloomington, they, if anybody would have known about it, and they didn't. And pretty much nobody else that I've spoken with. There's a governor's council for individual with disabilities. I spoke with them. Nobody really knows anything about it. It's pretty interesting. I spoke with the prosecutor's chief of staff about it a little bit, and basically explained, that it's probably not a reality. So the prosecutor's office is aware. My judge has already been informed that it's not. The thing is this statutorily created advocate is the language is written for criminal cases. It's specifically for an individual that's been charged with a crime. It's for a criminal defendant. But all the advocacy groups are usually not allowed to deal with criminal matters. It's like, if you call the ACLU and you try to get their assistance with something, they tell you, we don't get involved in criminal matters. If you're falsely arrested, they don't get involved. Like, doesn't matter how much your rights are violated. If the police arrested you while they're violating your rights, the ACLU pretty much tells you to kick rocks. So that's basically what all these organizations are doing, but they're being real courteous about it. But I could see if I was denied my own personal reasons, if they denied me personally. But it's more that I just realize there is nothing for an individual diagnosed with a communicational disorder to help them interact with the court, where what you say and how you say it and context, things of this nature, the words that you use, all of these things are very important. If you're an individual with Asperger's and you're charged with a crime and you have social cue issues and you appear odd or different, these things can greatly affect the way that your experience through the judicial system happens. The fact that there is, an immediate acknowledgement that there's a communicational barrier in the diagnosis without anyone acknowledging that this could have effects in an environment built on communication and punishment for what you say. It's very interesting that this is not a fulfilled thing, because it's a really good idea. It just hasn't actually been implemented, which is sad. Man. Some of you, it's really apparent that you don't pay enough attention to the videos because you don't realize that it's not that I've never told you, you've just never caught things. And it's interesting. It's interesting to see how much a really smart or a really not so smart individual told me a really smart thing one time. What they said was, people often provoke themselves. This is very true. I see this a lot in the comments. People who clearly don't pay attention to what actually happens in the videos or the things that are being said. And then they just continue on and on and on and on and on, repeating and getting more detailed with their own perception of things in the comments. And they're essentially having conversations with other people who aren't actually fucking paying attention and are ignorant of the facts. And then they reinforce it. This is the concept of trolling, isn't it? Pretty interesting. I'm of the notion that there's no way that I have as many views I do unless there's a bunch of police officers with multiple IP addresses watching the shit out of my fucking videos as trolls. Keeble Threeson. I think you would be much happier without all this conflict in my life. Maybe. Who knows? Coulda, woulda, shoulda. That's like the prerequisite language to like, you must be miserable. Like, just because I want police accountability and local government accountability, and I like to read the laws and things of this nature, doesn't mean that I'm like, where do you see a conflict happening right now? Like, I don't see a conflict. Like, I'm not miserable. Like, that's another common theme I see on trolls tend to repeat this shit all over YouTube. A lot of the same comments. See, the notion is that we are holy shit, 15%? How? The notion is that the people that are, First Amendment auditors, cop watchers, things of this nature, people that pursue governmental accountability clearly have all the time in the world because they got time to, spend an hour on something that they're passionate about. As well as that, clearly there's, standard, you're making these videos from your mom's basement, Social Security, you're worthless, blah, 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 blah. It's interesting because this is some harsh language to purposely direct at the disability community in general, because it's worthless, miserable. This is how Hitler literally convinced people to kill disabled people prior to everything else that he was doing. It's the life not worth living campaign. It's kind of the model for killing people based upon one characteristic. But it's, a lot of you people show your true nature. Basically, when you get to running off at the fucking mouth with, how someone that is identified as having a neurological disability is worthless and can't possibly contribute to society and things of this nature. And it's just, it's very interesting that you choose my platform to display your deep-seated prejudice nature on. I understand a lot of you come here from kiwi farms. Welcome to hell. I dox motherfuckers, so if you're stupid enough to fucking get on here and start talking shit with some sort of a link to your real identity, welcome to hell. That being said, I think I'm going to try to maybe wrap this up. My battery's dying. I'm going to try